Before I begin, I have a few remarks to make. I first want to thank our clerk, Patsy Spa, and her entire team, and Austin, our bailiff, and all his team for their work during the trial. I've had questions, who are these people behind me? They've never been introduced. This is Darrell Davila, my chief of staff, former prosecutor, strong legal background. This is Chris Sterner, my legal counsel, strong legal background, working for governors before this, and Lola Fender, our deputy chief counsel. They've done tremendous work. And of course, Judge Lana Myers, who served as a prosecutor on a criminal court in Dallas and on the Fifth Court of Appeals. I would not have been able to work through these last 2 weeks without them. As I said on day one, I've never been to law school, I've never taken a course, but we prepared for the last 3 months to do the very best job that we could to present a fair trial, which I think we have done to both parties during this time. We've read thousands of pages of documents of history of legal proceedings, and I even took a little bit of a judge boot camp along the way. So we've done the very best we can, and in a very short period of time, the trial will be in the hands of 30 members of the Senate who will vote. This impeachment trial, for only the third time of a statewide impeachment in the history of Texas, has been closely monitored, either through the media or through people watching online each day. I want to take a few minutes to go over a few of the key rules and to explain about what is to happen, because this is an unusual proceeding, not a normal trial. And I want to be sure the media reports it correctly and that the public understands everything we do will be in total transparency throughout this process. First of all, we've talked about the rules a lot in here. The rules were written and voted on by the members of the court. The final vote was 25-3. And these rules set out the framework for what has happened and what is about to happen. Let me highlight a few of the rules that we often get the most questions on. Pursuant to the rules written and adopted by the senators, Senator Angela Paxton cannot vote because of a spousal conflict. That's in Rule 31. However, the members kept the threshold to convict on any article at 2/3 of 31 members. That means it still requires 21 votes to convict, even though only 30 senators will cast a vote. It only takes a conviction on one article of the 16 articles to remove the Attorney General from office. Like any jury, the senators will deliberate in private, but under Rule 28, the senators will cast their vote in open court on the Senate floor without debate, one article at a time, after each member has finished their deliberations. All 16 articles will be voted on. I want to point out that under Rule 28, it provides that an article of impeachment is not divisible. What does that mean? That means the senators must consider each allegation in each article and determine whether the managers have proved each allegation in an article beyond a reasonable doubt before they can consider whether an article warrants removal from office. Then and only then may an article be sustained. For example, if an article has 3 allegations in it and only 2 are proven beyond a reasonable doubt in the mind of a senator, then a member shall not vote to sustain that article. Members, under the rules you adopted, I will read jury charges as written in Rule 27 after the conclusion of the final arguments. As I said in my remarks on opening day, your decision must be based only and only on the facts and evidence presented here in this chamber. You are the sole judges of the credibility of the witnesses. Evidence consists of the testimony of the witnesses and the materials admitted into evidence during this trial. Statements by attorneys in this trial are not evidence. Questions asked by attorneys are not evidence. I have no idea of how long the jury is going to deliberate. It could be hours, it could be days. Once they have notified me that all members are ready to vote, We will alert the media for a time certain when the members will come to the floor to cast their votes. And we will post that on the impeachment page of the state website. We will try to give the media and the public ample time to be ready for that time certain, at least 30 minutes notice. I know you are interested in the outcome of the trial, so check in on the website from time to time. No evidence whatsoever, members, outside this chamber shall be considered for any purpose. Nothing that I have said as presiding officer and judge, or that I have done, or how I have ruled, shall be considered as an opinion on facts or the case, and my words and actions should not influence your vote, one way or the other. I do not have the vote. You have the vote. The fact that the House of Representatives has preferred articles of impeachment to the Senate gives no inference of guilt. Like any defendant, the Attorney General is not required to prove his innocence or produce any evidence at all. The Attorney General is presumed to be innocent until proven otherwise. Even if a member believes the House managers have proven every element of an article beyond a reasonable doubt, the member may only sustain the article if they also believe Attorney General Paxton should be removed from office based on that article. The Senate jurors will begin deliberations today after final arguments, and they will continue as long as it takes. For the public, in some respects, understand this is like 16 trials in one. This is not a normal trial. They have to decide on 16 separate articles. Unlike a normal jury, the senators will not arrive at a group decision. When each member has come to their individual decision, they will come to the floor and vote one by one on each article. They will not have their phones with them during deliberations. They will not talk to staff during deliberations, legal counsel, or anyone else, members, only to each other during deliberations. They will be allowed, if necessary, depending on how long deliberations go, to sleep outside the Capitol. But under strict rules, members, you shall have no communications with anyone. You may not look at television, you may not look at your phone, unless it's a call from a family member, and they should not discuss anything. It should only be for a family personal issue. You can tell your kids good night, or your wife or your husband, but you shall not read any news, look at any news, go online, open up your computers. Before retiring to deliberate today, after closing arguments, each juror will be given a copy of the articles of impeachment. They will also be provided with all the exhibits that have been admitted into evidence. Both sides will have 1 hour for final arguments. The House Board of Managers, having the burden of proof, has the right to open and close final argument. They may divide their hour into any time segments as they wish for open and close. That means the House Board of Managers will argue first and last, but only for that total of 1 hour. The Attorney General's legal counsel will also have 1 hour for final arguments. Once again, after closing arguments by both sides, I will read the charge as you have written in your rules to the jury, and you will begin deliberation. I will now read the articles of impeachment. Article number 1, disregard of official duty, protection of charitable organization. While holding office as Attorney General, Warren Kenneth Paxton violated the duties of his office by failing to act as a public protector of charitable organizations as required by Chapter 123 Property Code. Specifically, Paxton caused employees of his office to intervene in a lawsuit brought by the Roy F. and Joanne Cole Mitty Foundation against several corporate entities controlled by Nate Paul. Paxton harmed the Mitty Foundation in an effort to benefit Paul. Article number 2, disregard of official duty, abuse of the opinion process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to issue written legal opinions under Subchapter C, Chapter 402 Government Code. Specifically, Paxton caused employees of his office to prepare an opinion in an attempt to avoid impending foreclosure sales of properties belonging to Nate Paul or business entities controlled by Paul. Paxton concealed his actions by soliciting the chair of a Senate committee to serve as a straw requester. Furthermore, Paxton directed employees of his office to reverse their legal conclusion for the benefit of Paul. Article number 3, disregard of official duty, abuse of the open records process. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552, Government Code. Specifically, Paxton directed employees of his office to act contrary to law by refusing to render a proper decision relating to a public information request for records held by the Department of Public Safety, and by issuing a decision involving another public information request that was contrary to law and applicable legal precedent. Article number 4. And both parties had asked me to read these articles before their closing arguments. While holding office as Attorney General, Warren Kenneth Paxton misused his official power to administer the Public Information Law, Chapter 552, Government Code. Specifically, Paxton improperly obtained access to information held by his office that had not been publicly disclosed for the purpose of providing the information of benefit to Nate Paul. Article number 5, disregard of official duty, engagement of CAMIC. While holding office as Attorney General, Warren Kenneth Paxton misused his official power by violating the laws governing the appointment of prosecuting attorneys pro tem. Specifically, Paxton engaged Brandon Kamick, a licensed attorney, to conduct an investigation into a baseless complaint, during which Kamick issued more than 30 grand jury subpoenas in an effort to benefit Nate Paul or Paul's business entities. While holding office as Attorney General, Article 6, disregard of official duty, termination of whistleblowers, Warren Kenneth Paxton violated the duty of his office by terminating and taking adverse personal action against employees of his office in violation of this state's whistleblower law, Chapter 554, Government Code. Specifically, Paxton terminated employees of his office who made good faith reports of his unlawful actions to law enforcement authorities. Paxton terminated the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Furthermore, Paxton engaged in a public and private campaign to impugn the employees' professional reputations or prejudice in their future employment. Article 7, misapplication of public resources, whistleblower investigation and report. While holding office as Attorney General, Warren Kenneth Paxton misused public resources entrusted to him. Specifically, Paxton directed employees of his office to conduct a sham investigation into whistleblower complaints made by employees who Paxton had terminated, and to create and publish a lengthy written report containing false or misleading information or statements in Paxton's defense. Article number 8, disregard of official duty, settlement agreement. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by concealing his wrongful acts in connection with whistleblower complaints made by employees whom Paxton had terminated. Specifically, Paxton entered into a settlement agreement with the whistleblowers that provides for payment of the settlement from public funds. The settlement agreement stayed the wrongful termination suit and conspicuously delayed the discovery of facts and testimony at trial to Paxton's advantage, which deprived the electorate of its opportunity to make an informed decision when voting for Attorney General. Article number 9, constitutional bribery, Paul's employment of mistress. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul's employment of a woman with whom Paxton was having an extramarital affair. Paul received favorable legal assistance from or specialized access to the office of the Attorney General. Constitutional bribery, Paul's providing renovations to Paxton's home. While holding office as Attorney General, Warren Kenneth Paxton engaged in bribery in violation of Section 41, Article 16, Texas Constitution. Specifically, Paxton benefited from Nate Paul providing renovations to Paxton's home. Paul received favorable legal assistance from or specialized access to the office of the Attorney General. Article 15, false statements in official records, whistleblower response. While holding office as Attorney General, Warren Kenneth Paxton made false or misleading statements in official records to mislead both the public and public officials. Specifically, Paxton made or caused to be made multiple false or misleading statements in the lengthy written report issued by his office in the response of whistleblower allegations. Article 16, conspiracy and attempted conspiracy. While holding office as Attorney General, Warren Kenneth Paxton acted with others to conspire or attempt to conspire to commit acts described in one or more articles. Article 17, misappropriation of public resources. While holding office as Attorney General, Warren Kenneth Paxton misused his official powers by causing employees of his office to perform services to his benefit and the benefit of others. Article 18, dereliction of duty. While holding office as Attorney General, Warren Kenneth Paxton violated the Texas Constitution, his oaths of office, statutes, and public policy against public officials acting contrary to the public interest by engaging in acts described by one or more articles. Article 19, unfitness for office. While holding office as Attorney General, Warren Kenneth Paxton engaged in misconduct, private or public, of such character as to indicate his unfitness for office as shown by the acts described in one or more articles. Abuse of public trust, Article 20, while holding office as Attorney General, Warren Kenneth Paxton used, misused, or failed to use his official powers in a manner calculated to subvert the lawful operation of the government of the state of Texas and obstruct the fair and impartial administration of justice, thereby bringing the office of the Attorney General into scandal and disrepute to the prejudice of public confidence in the government of the state, as shown by the acts described in one or more articles.